Welcome to Sykes, the Bottom Line Pharmacy Podcast, your regular dose of pharmacy CPA advice to fuel your bottom line, featuring pharmacists, key vendors, and other innovators.
Your checks, yes, you can call me, because we the best, Sykes and Company. We the best, Sykes and Company. Your accounting is a mess, there's no need for you to stress. Go online and request from the best. We the best, Sykes and Company. We the best, Sykes and Company. Yes.
Shoot, let's hop right in it. I'm Scotty Sykes. We got 007 Bonnie Bond here, the star of the show. Everybody knows she follows the podcast. Knows Bonnie's the star of the show. She signs autographs. And then we have Brad Howard here.
I did sign one.
I'd like one when we're done here.
Sure.
Brad Howard with Brown Fortunato, and we got Michael Alexander as well with Brown Fortunato. So we like to say Brown Fortunato is kind of the A-team with us. We work really close together with you guys on a lot of transitions, buy, sell, and other legal matters as well. And I know Jeff Baird's always kind of in the background stirring the pot.
He's 3 doors down.
Is he?
Well, I was just about to ask. I had a big question. I heard he had sold his house in Texas and that he is living a lot over in Utah now. So I'm wondering if someone's taken his office.
No, he's
keeping the office.
It's a great question. He lives at the Embassy Suites here down the street. He's got a house in Utah where his family is, but he's here in Texas a lot. So
okay, so he still has his office space. Nobody's
it's a nice office full of baseball memorabilia and
Scotty's been in there.
Yeah.
Oh, he's got like
taken
Mickey
some
Mantle
pictures
cards in there or something.
He's got Mickey Mantle. Yeah, I'm thinking that there's some pretty valuable stuff there to keep in the office.
Maybe we shouldn't say that.
Yeah.
Everybody to hear.
Yeah, sorry about that.
He's a great guy.
Bottom of the screen.
Yes, the address, you can look it up and figure it out.
All right. Well, thank you guys for getting on today. Today's topic, 503B. There's a lot going on here.
Yeah, there is.
So I guess I'll kick it off here, Brad and Michael. If you'll kind of fill us in on the current regulatory landscape. I know the FDA took, I think, semaglutide or tirzepatide, one of those, off the shortage list, back on.
Yeah.
Where are we? Where's the current environment right now in this space?
Yeah. So, well, first of all, thank you for having us. It's a pleasure to partner with you on these bottom line podcasts. These are cool. These are fun. I mean, I watch the ones besides what I've done and Jeff's done and Alfonso's done. I watch all of them. They're just full of content. It's really cool.
Yeah.
So it's a pleasure to be here. But it's also content that kind of makes you laugh occasionally, which is nice. It's not. We don't laugh.
Bonnie's real easy to joke on, so that's why.
Well, they don't laugh a lot in pharmacy right now, but you guys make everybody laugh.
They're saving a lot of blooper edits that they've had all year to do, maybe like a compilation at the end of the year.
Oh man, I know I've got a few of those that'll be on there, I'm sure. Well, it's great to be here. So thank you. I'm Brad Howard. I'm here with Michael Alexander, my colleague. We're part of a large healthcare group here at Brown Fortunato. We represent pharmacies, all kinds of healthcare companies, just all over the country and everything that they do. And it's great to be here because Michael and I work with pharmacies all over the country, day in, day out, and they are dealing with the things you're talking about, Scotty. They're dealing with FDA. They're dealing with state boards of pharmacy. They're dealing with shortage lists. And, kind of the way that I might kick this off. And if you don't mind, Michael and I sort of are kind of interchangeable. He's about 6 doors down. He's 2 doors down from Jeff Baird. And we tag team these questions all day long. So we may blur the lines here and just jump in and out, kind of try to provide as much content.
Oh, it's fine. Yeah.
Good. We want to give as much content as we can for pharmacies. We know they're dealing with a lot right now. So current landscape, I'm going to start with kind of a theme that resonates with me and with Michael based on our discussions all day long with 503As, with pharmacies. And that is that 503Bs are our frenemies, which I think maybe I made that word up or maybe it's real. But, in some regards, they're friends to the extent that, we're dealing with drugs that are on the shortage list, as we are. And we have a lot of patients out there, millions of patients who need to get access to their prescription medications. And the manufacturers don't have enough, then 503Bs have come in to kind of fill the void, fill the gap, help a lot of 503As supply patients with what they need. But then 503As, they're, compounding pharmacies is who we're talking about here. Compounding pharmacies provide prescriptions that are patient specific. And so a lot of what they want to provide to patients might look a little bit different than what 503Bs have traditionally provided to patients, which is kind of mass quantities of prescription drugs to healthcare facilities. So the lines are kind of blurred right now. Sometimes the 503A pharmacies, our clients, their best buddy is the 503B, down the road, so to speak. But then what Michael and I see a lot of, and others in our group see a lot of, is that 503Bs are honing in on 503A territory to serve patients individually with their prescriptions. So there's a little bit of tension there. So yeah. I'd say the current state of the relationship between pharmacies and 503Bs is they're frenemies. I bet Michael could add a lot more there because he talks to pharmacies all day long about these issues.
Yeah, jumping in on that just briefly, when you're talking about kind of the scope of what each type of facility can do, there's in circling back just kind of the regulatory landscape, there's still a great deal of uncertainty in the regulatory landscape in terms of what a 503B is and what it can and can't do. Now, we've received a lot of guidance from the FDA, which is the overarching entity that regulates and registers 503Bs. But then you get down to the state level, and that's where so much confusion exists. And so when we're talking about this concept of 503As and 503Bs and how they fit together and to what extent is there synergy, to what extent is there a little bit of potential for competition and competitiveness, understanding what 503Bs can do, not only on a federal level, but at your state specific level is something that's important for not only 503Bs to know, but for 503As to know. And that's where having a good knowledge and teaming up with experts in the industry or counsel to get that understanding for your operation specifically is still important. I'll use a quick example. You'll see this is in terms of licensing. So 503Bs are, of course, federally registered entities. So they are subject to, like a manufacturer, they have to register with the FDA. They're subject to risk-based inspections. They have certain reporting requirements. They're subject to standards that 503A compounding pharmacies are not. You drop down to the state level, and the states also want to impose their own regulatory scheme onto these entities because, hey, you're doing business into our state. You are either operating in our state to some extent as a resident facility, or you're shipping drugs into our state, and we care about that. But there's not been a great deal of consistency with respect to how are we going to regulate you. So you'll have some states that say, hey, this is just like a 503A pharmacy. You just get to do bulk compounding. And so they'll say, you're a pharmacy. You're just a 503B pharmacy. And then you have other states. So an example of a state that would say that you're a 503B pharmacy, I believe Alabama is going to regulate you like that. Other states like Texas, the Board of Pharmacy doesn't regulate them at all. They're regulated under a completely different department, and they're classified as a wholesale distributor. And so when you come in, the FDA is going to say, hey, 503Bs, you can do one thing. You can wholesale to these types of peoples. You can do this type of bulk compounding. And then you drop down to the state level, and Alabama might have a different answer for you in terms of what you can do and who you can sell to as a 503B than Texas might, because Texas is looking at you as a wholesaler. That's how you're going to be classified, and so you're subject to those restrictions and requirements. Whereas another state is going to say, no, you're a pharmacy. You need to act like a pharmacy. Why are you doing these things that look a whole lot like manufacturing and wholesaling? And so it's just, as a 503B, of course, you have to be aware of those restrictions. As a 503A, if you're working with a 503B to, obtain products, you need to know what your states are telling you. And that
I'm going to jump in there for a second. That's, if you don't mind, Scotty, Bonnie, with a little bit of Jeff Baird always uses the phrase inside baseball, like, something that maybe nobody else really kind of knows. So this isn't exactly that, but something that Michael and I and a lot of our colleagues who represent pharmacies all over the place. So what we're finding is like the first question is that the pharmacies ask us is, hey man, what's the law? Like, okay, with respect to not only generally what can I provide to patients and what can 503Bs provide to patients? And then third, where can we kind of do it together? Where is there some, synchronicity that our efforts together will take care of patients? What's the law? What can I do? And what we're finding is this: the FDA, has issued a draft guidance back in summer of 2023, which in a minute I want Michael to kind of touch on that because that's huge. I mean, it's a year ago, but it's still new news because it really matters for what pharmacies are doing, and state boards have all read it. So that's kind of the second part of what the law is. You've got the FDA saying, here's what we think the law is in the form of a draft guidance that's been out for 15 months. If I have a draft response to a client, it can't sit for 1.5 days. But, the FDA can sit on a draft guidance for 15 months. But then all the states, all these pharmacies operate in states, and state boards of pharmacy, as we all know, are the ones that regulate pharmacies, the 503As. And the states all have their own laws that are like on the books, the laws that anybody can look up. But then what Michael, spends about a third of his day doing is he's on the phone talking to board attorneys around the country and to boards of pharmacy because, okay, there's the FDA guidance, then there's the law on the books, then there's like this other set of unwritten laws and customs, case by case, temporarily and early and late 24 kind of laws that also really matter for what pharmacies can do. And it's important for pharmacies that want to operate, especially where there are, shortages. And Scotty mentioned this at the beginning, where there are product shortages. So there's a shortage list that FDA has put out there. And the question is, who can provide the product? Well, that third set of laws is the kind of unwritten laws and customs of the tribe, going back to the Native Americans, they're not written. They're just passed down from those in the know to the next generation. It's kind of like that in pharmacy law right now, where there's that third set of law of, well, what are the states really going to do?
Right.
What do they really think about what a pharmacy can do and what a pharmacy can do with a 503B? And if you don't mind, I might kind of give you a super timely example of where things are really.
Oh yeah, please.
Very interesting.
This is
great. Oh yeah, this is good.
Yeah.
Awesome.
Okay, well, I hope you like Michael and I talked before the call, and I'm like, okay, we're not going to name any client names. We never do that. But we deal with this stuff all day long, and it's super interesting to us, and a bunch of our colleagues down the hall and around the country deal with this stuff. And to us, it's fascinating, but it's uncomfortable. It's uncomfortable for, as lawyers, we like to know the law. Obviously, we know the law. We study the law all day long. But then, you might get an email 6 a.m. on your listserv, and hey, what do you know? The third thing, the unwritten laws and customs, maybe it changed overnight. Or maybe a lawsuit got filed. And then Michael will text me at 7 a.m. Hey, man, before you get in the office, you need to read this thing.
Yeah.
I'm like, oh, well, maybe we should tell the whole group about it because the law may have just changed, at least for, today. So here's what's kind of interesting is that I'm seeing a lot of now that I've been doing this for 32 years. Michael's been doing it for 14, 15, a long time. We've been doing this. And then we have colleagues from Jeff's been doing it for 40 years to others who've been, 3 or 4 years and kind of everything in between. And the one thing that's interesting to me as one of the older guys in the group is back in the old days, people would file lawsuits and it would kind of change the whole dynamic, the regulatory dynamic. And then that kind of went away. I didn't see much of that anymore. Lawsuits were filed, lawsuits got dismissed. Maybe it was newsworthy for, a day or two or a week. Not anymore. What we're seeing in the compounding space is that some of these industries, associations, and some of the larger players, we have a lot of pharmacy clients that are nationwide and they're 50 states, and maybe, maybe some territories, and they're trying to provide products to patients all over the country, and they're trying to figure out what can I do and what can't I do. And pharmacy associations, trade associations are putting out newsletters every day or every week telling their members, hey, here's what you can do. Timeout, change that. Actually, now here's what you can do. But I'm seeing lawsuits come up that aren't getting thrown out and that are kind of game changers. Michael's a reformed trial lawyer. He joined our firm from a firm that they prepared and tried cases. And Michael's all about that, but he really sort of likes to get in the weeds on what the law is and what the law isn't, and help businesses kind of navigate all that. But a lawsuit got filed in Fort Worth a couple weeks ago, and that's, Scotty, you mentioned earlier, tirzepatide, sometimes known as Mounjaro, but it's a weight loss drug. A lot of pharmacies are compounding versions of it to meet supply shortages, but also because a lot of people can't take injections and maybe they need it sublingual, or they need it administered in different doses. That's what compounders do, right?
Right.
So the FDA says that tirzepatide's on the shortage list, and that was the law. And so our clients, the 503As, are supplying, and the 503Bs are coming to kind of fill the void with supply disruptions. And then one day, Michael and I we always talk a lot early in the morning because he's got a bunch of kids, so he likes to get up early in the morning before his kids are up, and we talk about what happened last night in the law, because it's changing all the time. So suddenly tirzepatide is not on the FDA shortage list. So there's this industry panic. Like, man, what the hell are we going to do now? Like, we're compounding a bunch of tirzepatide, and a bunch of 503Bs are like, hey, can we still, what can we do here? But, most of our practice is 503As. We mostly represent pharmacies around the country. What can they do about this? And then a lawsuit gets filed in Fort Worth. We have an office in Dallas, so just right down the road from our office. Gets filed in Fort Worth in front of a very conservative, very smart judge, but a very conservative judge who's also taken the FDA and other agencies to task in some of his rulings, because he doesn't feel like the government should overstep its bounds. And then this lawsuit gets filed saying, hey, maybe the FDA violated the law because they took tirzepatide off the shortage list. But even in their notice said, hey, this may cause some disruption. And so we were laughing about our group, like, well, is it on the shortage list or is it not? You just took it off the shortage list, but in your own proclamation, you're saying there's a shortage. So we regroup. Hey, what is the law here? What are we going to tell these pharmacies? Pharmacies don't want to be in trouble with the FDA, but all of our pharmacy clients are trying to take care of millions of patients around the country. So what do we do about it? Well, then a lawsuit gets filed by a 503B industry organization. They've got three letters: OC, OFA. I can't think. Anyway, their outsource industry association. They file a lawsuit in Fort Worth and say, hey, we want an injunction against the FDA. The FDA can't say tirzepatide's on the shortage list on Monday and then say, on Tuesday, there's no shortage.
Yeah.
which is
like, it sounds like job security for you guys.
Well, so yeah, it's patently unfair.
It sounds like, first of all, a good movie. Like, this is like a good book. Get your popcorn.
It is.
And it's bringing back some like PTSD, because when tax law changes next year, we're going to be, Bonnie, in the same shoes.
Well, I was just thinking, you guys are in a similar profession as us, that you can't just learn something and then be really good at it forever. It's constant change, constant. And then when you bring the states, we deal with the same thing.
Bingo.
We can figure out something on a federal level, but then you have, all these states that can be completely different and have different views on
what's going on.
It's
the exact same thing. It's the exact same thing, because we've provided, we always provide the advice, and here's what the law is now. But then, if you want to be a good servant to your clients, you're going to forecast where you think the law might be going and how they might want to, like chess. Let's think 3 or 4 moves ahead. So it's not, it's not over in 5 minutes. And so we're looking at what the law is. Hey, tirzepatide's on the shortage list, but also we're advising clients, hey, the law is it may change. At some point it may change, and we may have a kind of a runway. FDA may give pharmacies a runway. 503B might have a runway, all things that we're talking to the clients about. But now, like on Monday, it's on the shortage list, and on Tuesday, it's not. And so our phones were blowing up for the entire week. Hey, what's the law now on tirzepatide? Can I compound it? Can I not? What's going on? Well, this lawsuit got filed by this industry association for 503B suppliers in Fort Worth in front of a very conservative federal judge, a genius guy, but also a guy who doesn't think the government just has from what I can tell, doesn't think the government has unfettered discretion to do whatever the government wants. He's going to hold them accountable.
Right.
So this injunction says that they filed for says, hey, you can't be on the shortage list one day and not the next day. FDA's got to do better rulemaking than that. You got to give notice to pharmacies. What are patients supposed to do if you're acknowledging that there's not a shortage any longer, but patients might not be getting their product? Well, it sounds like a shortage. So they filed this lawsuit, and I think they caught, Michael and I and the whole group were talking about this, hey, what's going to happen in this lawsuit? Because I don't think it was just thrown together overnight. We think they sort of had it in their back pocket, knowing that maybe, something was going to happen. And this lawsuit gets filed. I think the FDA got caught kind of flat-footed. And they're trying to get their lawyers admitted into federal court in Texas, right down the road from us and it was a pretty solid looking lawsuit going, hey, the FDA can't just say, here's the law today and here's the law tomorrow. And the FDA put a hold on it, kind of put a timeout and said, okay, on tirzepatide, let's wait. Yeah.
I don't want to get political here, but government dysfunction is just sounds like government dysfunction, man.
Well, it's so, yeah. And so this isn't political at all, because the federal government regulates all of our clients, and some yours and mine, right? All of our pharmacy clients that you do tax work for and provide all kinds of other financial services, and we handle, legal matters for them. All of us care about what the federal government does. It's huge. The FDA, DOJ, FTC, the OIG, HHS for federal payers. They regulate all of our pharmacy clients. And of course, IRS and others regulate all your pharmacy clients in the tax world. So I think that, and Michael and I talked a lot about this, how are we going to kind of forecast what things look like for clients? And then the lawsuit comes in and sort of puts it on ice for a little while. So now the FDA is not going to enforce the tirzepatide as if there's not a shortage. They're going to kind of take a time out and think about it. They're regrouping, and a lot of our clients are regrouping, and that's what Michael spends all day advising clients on. What is the law now? What's the law going to be at the end of November? What's the law going to be in December? What's the law going to be in January? But a lot of what we're advising clients on with respect to 503As and Bs is a lot of this law is timeless. You have to understand what a 503A can do, what a 503B can do, and then understand that with these shortages and the weight loss drugs, some of that's kind of fleeting. We'll still be dealing with 503As and 503Bs and the legal tension long after all this gets resolved. So,
but you look at it. Oh, sorry, I didn't mean to cut you off. But when you look at you use the semaglutide from Novo as another example of where you have to really have your ear to the ground in the market. Novo, of course, has been trying to ramp up its production for ever since it went on the shortage list. But you see them, increasing the manufacturing space for the production of these semaglutide products. And the FDA I believe it was a week ago, might have been a week ago Friday, the Wegovy and Ozempic are still on the shortage list, but they're now listed as available. And so what does that mean? You're talking about something that's still on the shortage list, listed as available. Okay, well, 503As, 503Bs, what can we do? Well, it's still on the shortage list. So good news there. But, start to read the market. Here's what Novo is trying to do. And Novo is also, it's not new news, but it's kind of just a continuation of the old news. They've been very aggressive in their attempts to tamp down and stamp down the compounding of these products, whether that's through suits related to product infringement or trademark infringement, whether that's related to trying to get these products listed on the difficult to compound list, which again is going to probably have to go through the whole rule notice making process at the FDA to get it added to that list. But that would really impact what compounders are able to do.
which is news to a lot of our clients who are compounding. It's not difficult to compound at all. It's they know what they're doing, and they're compounding it very, very safely. And so interesting, Michael and I just talked about this because, Novo filed a application with the FDA, with regard to semaglutide to try to get the train going towards it's difficult to compound, and maybe that's a different status. That, the evidence they kind of cited was, a handful of cases where people got hurt from compounded, product. But then if you look at their own history as a manufacturer and, injury claims and the like from patients who've used their product, then those numbers might tell, kind of a contradictory story, at least the pharmacies would say. And, it's nice that we have our ear to the ground and we kind of hear these things coming before the train shows up at the station. We can tell it's, coming down the tracks. But yeah, there's a lot of stuff for pharmacies to keep their eyes and ears on in the industry right now.
Yeah, I was gonna say, you got the federal, you got the state, and then you have, the manufacturers themselves that are also adding pressure and uncertainty, in the space. I see them on CNBC every other week talking about this issue and saying they're not as safe or whatever. I mean, they got their agenda they're pushing on their end as well. So that throws a whole kink in everything too. I mean, right?
Oh yeah, they've got their own. I mean, manufacturers have their interest in ultimately, and
a lot of. I don't mean to cut you off, Brad, but a lot of pharmacies I talk to that are not getting into this area, they don't want to deal with, I think, the potential litigation from any like manufacturers or whatever. That's kind of what they are telling me. Like, I don't want to be a potential lawsuit down the road or something.
I get that, but then Michael and I get these demand letters for clients on behalf of manufacturers, and a lot of those we read and just kind of, you chuckle a little bit because we have pharmacies all over the country. So maybe like 10 pharmacies all got the same letter. Mm-hmm. They try to make it sound like it's specific to, an individual pharmacy or whatever. It's a kind of a form letter from a lawyer. And then you check out the lawyer, and the lawyer is not a pharmacy lawyer.
Yeah.
In a lot of cases.
And frankly, so much of it, from just the pharmacy perspective, there's a great deal of comfort in the shortage list, because that comes in and really cuts the manufacturer's claims, at least some of their claims, off right at the knees.
Yeah.
If it's on the shortage list, then that comes in and really just provides the allowance and the permission for compounding pharmacies to come in, or 503B outsourcing facilities to come in and engage in that conduct. So, say, hey, you're infringing on my patent. It's like, well, your patent is currently in shortage. So the FDA says I can compound it, so I'm going to compound it.
Right.
And so, it's not to diminish the significance of those letters, because they can be scary when you get a big manufacturer coming in against a little retail compounding pharmacy who's local, just trying to serve their patients.
Mm-hmm.
But, there's the real claims that have meat and bones to them are the ones related primarily to product infringement. So not the product infringement, but the trademark infringement, where you're being deceptive in how you're marketing this stuff. And so those are the ones where we've seen more aggressive, or I've seen more aggressive conduct by the manufacturers, and they've had more success at the state levels, because it's like, hey, you're basically just doping my marketing and using it to sell your compounded product. That's exactly why trademark infringement is out there, is to prevent that sort of conduct. But with respect to, if you're just compounding, these types of products, not trying to steal their marketing, not trying to steal their branding, just, hey, I've got a prescription from a physician who can't get Ozempic, and he needs me to compound for his patient, an essential copy of Ozempic because it's currently on the shortage list. Mm-hmm. Manufacturers don't really have a whole lot they can say about that, because it's on the shortage list, and I'm doing it pursuant to patient prescription, and I'm not marketing it as Ozempic. I'm just, hey, I can compound the same type of product. Yep. It's not Ozempic, because it's not it's not manufactured by Novo. So, there's been that type of actions by the manufacturers against compounders. Some of the other directions they've taken, which has been to go to the state boards. And again, this is somewhat old news, but it again demonstrates what they're doing, which is saying, hey, you get the letter from the state board, and it's the same letter that this other state board sent me. That's the exact. It's just this Novo wrote this. So it again comes down to what are states doing, and some states have taken that route. They've gone the route of Novo and have followed that. So hey, you can't be doing this because of XYZ reason. And when that comes up to my clients, they email me and say, hey, North Carolina said this. What do I do? It's like, well, that's the effective position of North Carolina, and if you're at a regulatory risk if you continue to compound this product into North Carolina. Is Texas going to take that route? Well, Texas hasn't said. The Texas generally follows the FDA's position on these issues. I was at a conference recently, and it was interesting because there was a Board of Pharmacy panel, and they were talking about, okay, like, what do we do? How does the board interplay with the FDA? And just to kind of see the divide sometimes pop up, where sometimes the Board of Pharmacy representative is saying, well, like, you really have to look at our regulations and what we're saying. And other states saying, we just rely on the FDA to make those determinations for 503Bs. And if the FDA is fine with that determination for a 503B, we'll follow their guidance. And so it again comes back to the FDA has its overarching guidance, but you really got to drop down to the state level as well and say, okay, I'm in Rhode Island. What is Rhode Island doing? Are they following just kind of what the FDA is telling them to say? Or are they going to come in and be more aggressive, like Mississippi, in their newsletter, came out and just directly contradicted the FDA's position on, the wholesale prohibition and what 503B compounders or 503 compounding facilities can do. The FDA says, hey, here's our interpretation of, the FD&C Act in terms of who you can, sell your products to. There's what's known as the wholesale prohibition, which just says a 503B compounding facility cannot sell or transfer its product to any other entity apart from that outsourcing facility, with two big exceptions. One being you can sell it to an entity that is going to administer it pursuant to a patient prescription, or you can sell it to an entity that will dispense it pursuant to patient prescription. The FDA comes out and says, hey, that dispense language, that means pharmacies. You'll read that draft guidance from last year and say that means pharmacies. You jump down to Mississippi says, yeah, we disagree. Not we disagree based off of state law, which some states will do. Some states will say, yeah, that's the FDA guidance, but you can't do it pursuant to our state law. Mississippi just jumped up and said, we just disagree that that's the proper interpretation of the statute.
Yeah.
And so
we got a client in Mississippi, and it's just been so frustrating.
And so
they have a different point of view about what the FDA says.
Yep.
Can happen and can't happen, and that's why it's interesting. Is a lot of our clients are regional or nationwide, or they cover a big swath of states or maybe the whole country. So the advice we've got to give is not only here's what federal law looks like, but it's nuanced for where they're doing business, and then also it's nuanced for maybe some states don't officially proclaim what the law is, but they have a viewpoint about what the law is.
Yeah.
You want to figure out what that is and you want to navigate it.
So due diligence is key here, obviously. We've been saying that a long time. And now I got one more question here. Like, with the election now behind us, and from what I'm reading, there's going to be some big old changes going on with a lot of these agencies, supposedly, and that's what they're trying to do anyway. What's the crystal ball telling you here, Brad, Michael?
So that's a very good question, and I want to get it right, because if somebody watches this podcast in March, I don't want them on. That was all wrong.
We had to be careful. We were doing all those PPP podcasts and different stuff we were putting out. We have to pay attention to the date because it changes.
The interim
every
final
week.
rule.
Yeah.
The interim final rule. Has anybody ever heard of an interim final rule? I don't.
No.
Oh my gosh.
No, we specialized in COVID law during that first year, so we did all the same thing. Like, hey, this webcast is good for this week. We'll see, what happens. But no, it's a great question. So, what we think, at least Michael, I won't speak for the whole group, but Michael and I have talked about this. What we think is that the new administration is certainly going to tighten up things on FDA. Some of what you read is that there's not a federal agency that they don't want to severely, restrict. But FDA is kind of different. Like, you go back to New England compounding center back in 2013, and a bunch of people died. And that's just one example. But, there are reasons that FDA exists to regulate a lot of these products. And, while some of our clients and as a firm, we may have some issues with some of the rulemaking and the proclamations and shortage today, no shortage tomorrow, the FDA has an important role. So we don't think they're going to be eliminated or so severely restricted that they can't, try to provide oversight for safe products. What we do think is that maybe they're going to take a little bit lesser of a role in states. Will continue to elevate kind of the importance in their role for regulating these products and ensuring patient safety, which isn't a lot different than what Michael and I have seen, for years. Is the states are really the ones that regulate the pharmacies, the state boards of pharmacy do. We don't see anything changing that way coming 2025, but I would not be surprised to see some things in place where FDA can't make a decision like today, here's the law, and tomorrow, here's the new law.
Yeah, makes sense.
I think that's a fair assumption.
And then there are a lot of judges being appointed, will continue to be appointed, who have a little bit different view about what the government can do. And sometimes the Court of Appeals won't agree with them and will take their decision down. But what we're seeing more of are decisions coming out where federal court judges are looking at, hey, did the federal government have rule-making authority to come up with this rule kind of overnight or on the fly? And they're challenging that authority. So I think we're going to see a lot more challenges to federal authority in the next few years. I think we're going to see states having an even more important role, which Michael and I, we deal with states all day long. So we're okay with that, because you just have to know what the law is or know enough people to figure out what the law is that's not written down. And once you do that, then you can help pharmacies navigate all that.
Yeah.
Well, it'll be interesting for sure for everybody in all areas, I reckon.
Yeah. Well, for you guys too. I mean,
IRS is 30 years behind the time, so good Lord, anything's going to help them.
And you overlay the whole administration change with, Loper Bright got struck down. What has it been? Oh gosh, Brad, was that last Supreme Court term or the one before? But we're going to see the impact of, we get all this FDA draft guidance. It's like, well, how much is this subject to challenge now that Loper Bright's gone? And how much are we going to see, the challenges to rulemaking authority come in and say, no, you don't get to do that. Chevron's gone. We don't have to give you deference anymore. That's going to shake out at the FDA level as well. And to the extent states have adopted Chevron, it might impact it as well. That's going to be to a lesser extent because they're their own co-equal sovereign. So it's just like, hey, but the administration change plus the whole regulatory landscape already being in shift because Chevron was struck down through Loper Bright is going to lead to some I don't want to say chaos in the industry, but some uncertainty in the industry moving forward. But
so we'll keep reading the law late at night. We'll read the law first thing in the morning so we can stay on top of it.
Uncertainty is good for the podcast because we get you on here and we try to figure out uncertainty.
Well, your stuff is but your stuff is so recent. Like people, I watched a few of your podcasts last week just to prepare for this one and to see what works. And, what I found was everybody's giving very current information and their take on things, and it's still all very relevant months and months later. So it's a privilege to be here and talk about it. And we'd love to come back and talk about what it looks like, early in 2025. Well, it's great to see you guys. Thank you for having me.
Thank you, Brad. Thank you, Michael.
Yes.
Appreciate y'all coming on.